Let me say this very clearly. More US visas are refused for non disclosure than for the crime itself. Hello, my name is Lara Akinlude, and I'm the managing attorney at Lardell Law. If you're applying for a USB 1/B2 visitor visa and you're unsure whether a past issue, arrest, or conviction needs to be declared, this video is essential. Today, I'm going to explain what crimes must be declared, why honesty matters so much in US immigration, and where many applicants make serious and avoidable mistakes. 1. The Golden Rule. Disclosure is mandatory. US visa applications are based on full and truthful disclosure. This means you must declare our arrests, charges, convictions, even if the case was dismissed, even if it happened many years ago, even if you believe it was minor. If it appears on a police or court record, it should be disclosed. 2. Spent or expunged convictions still matter. Many applicants assume that if a conviction is spent, expunged, sealed, or no longer visible locally, it does not need to be disclosed. That is not true for US immigration. The US does not follow foreign spent conviction rules in the same way, and failure to disclose is treated as misrepresentation. 3. Arrest without convictions. Even if you were arrested but not charged, charged but not convicted, or the case was dropped, you're still required to disclose the arrest. The officer will decide whether it matters. Your role is to answer honestly. 4. What happens if you don't disclose? This is where many applicants get into serious trouble. Failing to disclose can lead to immediate visa refusal, findings of fraud or misrepresentation, long-term or permanent visa bans. In many cases, the non-disclosure is more damaging than the offense itself. 5. Not all crimes lead to refusal. This is an important point. Not every crime results in automatic refusal or permanent ineligibility. Some offenses may be waived, require additional processing, or have no impact at all. But that assessment can only happen if the information is disclosed properly. 6. How to approach disclosure correctly. Disclosure does not mean over-explaining or panicking. It means answering the question accurately, providing truthful details, being consistent between the DS-160 and the interview. How something is explained matters almost as much as what is disclosed. If you're unsure whether something from your past needs to be declared, it's always safer to ask before you apply rather than guess. Many applicants are eligible for US visas even with prior issues, but problems arise when mistakes are made at the disclosure stage. At Lardell Law, we help clients assess criminal history issues carefully and present them correctly so avoidable refusals and long-term consequences are prevented. Thank you for watching. And in the next video, I'll explain whether a DUI or theft conviction can still allow you to get a US visa.